I'm Regina McCann, Hess, President of Forge Wealth Management. Today, we're going to talk about 9 important estate planning steps. Your estate planning has an impact that can reach beyond financial issues and your lifestyle to include your family. Estate planning involves many complex concepts that are regulated by varying state laws as well as federal laws. So as you begin to consider what kind of legacy you want to leave to your loved ones, be sure to seek insight from your team of professionals and make sure that includes an estate planning specialist and a tax attorney. Step 1, creating a will. Now, a will is essentially a document that states how you want your assets divided after you're gone. So creating a will is the first important step in planning your estate. A will provides an individual with the opportunity to nominate guardians for minor children or dependents, as well as the executor for your estate. Now, the executor serves the vital function of gathering and dispersing the assets of an estate and seeing that all the related tax issues are handled. Now, remember, like the executor is someone who's going to be doing your bidding. How your will is written, the executor is going to have to follow those instructions for how your money is basically given out after the fact. So it's a big job. So you want to make sure that you choose wisely. You may choose a professional who can handle those matters on his or her own, or you may choose a relative or a friend who can also hire any professional help he or she may need. However, please be sure the friend or relative is willing to serve in this capacity. It's not really a fun surprise when you're already gone for somebody to find out that they're the executor of your estate. You have to make sure that they're willing to do it. It is a lot of work. So, be honest with the person that you're asking to be the executor, that they're going to have some work to do. Step 2, update beneficiary designations. So this is something that I do see often in practice. People have a will and then they don't update the beneficiaries on their other accounts to reflect what the will states. So beneficiary designations should be reviewed periodically and kept up to date, especially after major life events such as births, deaths, marriages, and of course, divorces. Now, if beneficiary designations for such things as retirement accounts or insurance policies are outdated or inaccurate, your assets may pass to the people you did not intend to benefit. So in other words, if you have your brother Mike as your beneficiary on your will for your assets, but in your actual retirement account, it says your brother Tom, well, guess what? Tom's getting the money, Mike's not getting the money. So make sure that your beneficiaries reflect the same beneficiaries that are listed on your will, because it will go by, the IRA, the retirement money will go by who you have assigned as beneficiary there. Step 3, establish healthcare directives. So basically, in the event that you become incapacitated or terminally ill, it is important to have your wishes regarding your medical treatment documented. So basically, you're creating or designating a healthcare proxy who will be authorized to make medical decisions for you if you are incapacitated. So again, you want to make sure it's somebody who is willing to take on that task, who knows that that's their task, and also what your wishes really are. Don't leave it a surprise to them as to whether or not you want, life-sustaining type of heroics done or not. Now, the rules governing healthcare directives do vary state to state and can be affected by federal law. For example, the Health Insurance Portability and Accountability Act, which we all know as HIPAA, restricts your physician's ability to disclose your medical information. So to prevent this from occurring, make sure that to include a HIPAA release language in your disability planning documents. So just a little bit of mom advice from my friends, as you hear these stories and you hope to God they're never, you getting this phone call, but you could get a phone call in the middle of the night. Your adult child, right, is in the ER of the hospital And that's all they can tell you. They can't tell you pretty much anything else. Are they alive or dead? Pretty much. That's what they can tell you. You can't find out what's wrong. Is it, life altering? Do I have to get on the next plane, trains, and automobiles to get there? They really cannot release any information whatsoever, which would be a horrible situation to be in. Not only are you worried about your child, but you're also, have no information. So you're running there in a vacuum. So this is something that many of my mom and dad friends have suggested to me before my kids went to college. And I am passing on that advice to you. Even though we're talking about estate planning, I think it's really, really important if you have adult kids in other states to make sure, and your own state, of course, to get one of those healthcare proxies for them. That's the end of my soapbox for that particular comment. Back to estate planning tips. You can see sometimes where you can use these not just for estate planning, but for other, daily life circumstances as well. Okay, now step 4, consider a power of attorney. It is important to be certain that your financial affairs will be managed if you become disabled. So you want to talk to your estate planning professional about creating a durable power of attorney that authorizes someone that you trust to handle your financial matters. So be sure to have your documents reviewed periodically to make sure they are up to date and compliant with current laws. And what does that really mean? What does that power of attorney do? Well, they can pay your bills, they can run your bank account, they can run your investment account until you're back up and running for as long as they need to, and basically pay the bills that need to be paid while you're incapacitated. Sometimes it's a short-term thing, sometimes it's a longer-term thing, but the last thing you want to do is, not be able to have anyone help you during that time for the financial side of things. All right, step number 5, establish a trust. One of the primary purposes of a trust is to avoid probate, which may mean that your estate can be settled more quickly and at a lower cost. Perhaps more important to some individuals is that a trust be private, whereas probate proceedings are a matter of public record, right? So anyone can go see anything that's at probate, but a trust they can't dig into and basically find your information. Now, because there are several types of trusts, you should contact an estate planning professional to determine which type of trust is for you. There's various things that you could talk about there. Step 6, plan for the distribution of your retirement assets. It is important to plan carefully when completing the necessary beneficiary forms. If you are participating in an employer-sponsored retirement plan from which you're eligible to receive benefits, be sure to keep plan administrators advised of your current address and keep your beneficiary designations up to date. Also, make sure your beneficiaries know about any plans from which you may have benefits coming from. And the address, the current address, can be very important. And it's funny because sometimes you think you have updated your address, maybe times multiple times, and you call in and they still have an address that you lived at 9 years ago. That happens often. So, maybe make that part of your annual review of your assets and liabilities, just making sure everyone has your current address. And especially in the time of most people are getting their statements online. They're not getting physical statements anymore. For those people, that's even more important to make sure that they have your updated address. Step number 7, use gifting strategies to reduce estate tax liability. Gifting can be an excellent way to potentially reduce the taxable amount of your estate. One common gift giving vehicle is the 529 savings plan. Now, in this plan, assets potentially grow tax deferred and can be withdrawn federally tax-free if used for qualified education expenses. So in 2022, an investor can gift up to $16,000 per beneficiary on an annual basis. Couples can gift $32,000 per year per beneficiaries. Donors can also make what we call an accelerated gift to a 529 plan equal to 5 years worth of gifts. Now that would be $80,000 for an individual or $160,000 for a couple to each beneficiary. Now, in those circumstances, you do not incur federal gift taxes as long as No additional gifts are made to the beneficiary for 4 years after the year in which you make the one-time gift and the appropriate tax form is filed. Okay, charitable donations are another form of gift giving. Any assets donated can reduce the overall value of the taxable estate and are often income tax deductible. Step number 8, decrease or eliminate estate taxes. Passing to a surviving spouse is generally exempt from estate taxes. As of 2022, there is a 12.06 million limit for individuals on the amount that can be passed on to a decedent's non-spouse heirs estate tax-free. Discuss with your estate planning specialist the ways you might structure your bequest to take advantage of the exclusion and minimize estate taxes. There are a variety of ways to decrease the taxable amount in your estate. Many Americans can minimize estate taxes through careful estate tax planning. Step number 9, determine how to draw down your assets. During retirement, it is important to consider what sources of cash are being used to maintain your lifestyle. These sources often have drastically different tax consequences. So discuss with your financial advisor the best way to draw from your tax-deferred, taxable, or tax-free assets for cash flow needs to minimize your own taxes and the taxes to be paid by your heirs. With careful planning, you may be able to avoid common mistakes and help ensure that your heirs are not burdened by unnecessary emotional and financial stress when settling your estate. We have a few key steps to remember. Estate planning steps include creating a will so that your wishes will be honored, and also keeping beneficiary designations on your insurance and retirement counts up to date and reflect your will. Also, you want to talk to your professional advisors about consolidating your retirement assets, as well as using trusts and gifting to help lessen your estate taxes. Now, consider the benefits of protecting your interests by taking steps to avoid probate and keeping a certain amount of your assets in cash. And as usual, I'm going to tell you that this is for educational purposes and not intended to be investment advice. Thank you so much for joining me. Again, I'm Regina McCann, president of Forge Wealth Management. My website is forgewealth.com. You can find me on social media, Facebook, Twitter, and YouTube at Forge Wealth, and LinkedIn, Regina McCann. Go have a great day.